am Anthony Purgis. I'm a partner with Reynolds, Mirth, Richards and Farmer. With me today is Matt Woodley, who's also a partner. We are primarily our focus is on labor and employment law, and we have been, as you can imagine, working feverishly to keep up with all the updates as this situation with respect to what we'll call COVID-19 for short, but this pandemic issue is increasing. Now, we also have been, there's a number of lawyers at our office who deal with this, and we've all been keeping each other in the loop and keeping the information as current as possible. So, you're free to reach out to either of us after this webinar if you have any questions, or really anyone else at our office. We'll also be able to assist you on this. I do want to thank everybody for attending. It's much appreciated, and just so you know, this is doing a webinar from my house is a relatively new experience for me, and so we're working through this as best we can. We felt it was important, given the scope and the degree of changes, and frankly, given how much effort it was taking us as legal professionals to keep up to date on everything. We felt it was important for our clients and for employers out there to get kind of as educated as possible, and to hopefully we can alleviate some concerns. We can reduce kind of the panic, and we can hopefully provide you with some items to think about and some options to think about as you're going forward with respect to your time here, and respect to what your organizations are dealing with respect to this pandemic situation. Before we get into the substance of it, I do want to mention a couple of general kind of caveats or notes. Is first, this is general information we're providing here. We'll do our best to kind of advise the organizations it tailors to. So for example, there's some things we might mention that apply to unionized workplaces that wouldn't necessarily apply, but we'll make sure to identify that wherever possible. Another thing to be aware of course, is we're providing the best and most accurate information we can at this point. That being said, there could be a government announcement going on right now that I'm not aware of that could change a number of things. And one of the things that we're trying to be careful of is, I'll talk briefly about this, but there was some confusion earlier this week when on last Friday, the provincial government announced a 14 days paid leave that is now, and I'll talk about it in more detail, quite clearly is an unpaid leave. And so what we're trying to work with here is the best and most accurate information that's available, and pass it along to you. But as mentioned, it could be changing. And so, you'll want to keep that in mind as things progress. One of the main things, a couple of other housekeeping items, we've turned off the Q&A function because of the breadth of this webinar. We want to make sure we get as much information to people as possible, and I don't want to be kind of going down too many rabbit holes on a Q&A sense. But at the end of this session, we'll give you our email addresses and our contact info, and you can reach out to us for kind of specific legal advice. As mentioned, also any other lawyers in our office who work in the field of employment are able to help you here. If you do have any technical issues while this is ongoing, please email client relations, all one word, at rmrf.com. That will get to our behind the scenes person, our business development person, Christine DeWitt, who will hopefully be able to assist you if there's any technical issues. If for any reason the webinar fails or cuts off, we are going to do our best to make it at least available to you in a recorded form if need be later today. In addition, assuming everything goes smoothly today, we will be providing a follow-up email that will provide access to a recorded webinar and the like. So one of the things, again, is just a broad general introduction to keep in mind is we are now, as of 2 days ago, in a public health emergency as declared by the province. So this has given the provincial government enhanced powers with respect to acquiring property, with respect to requiring individuals to assist with the emergency, and allows them and the chief medical officer to make substantial changes and authorize, for example, the absence of employees from work if they're ill or caring for a family member. So some of these things can change quite quickly. From a practical perspective, this does not mean that the existing laws in Alberta are going, are not applicable. So we still have the legal framework that we're working with, but you need to be aware that it's possible that your business may experience significant interference from public health officials as they're exercising powers pursuant to the Public Health Act. And as many of you are likely aware, this has already taken the form of impact for certain businesses being shut or reduced. I was actually for another reason in Toronto recently, and they're allowing no dining whatsoever. It's takeout only. I know in Edmonton here, it's been reduced to the restaurant capacity has been reduced. Another thing to keep an eye on is if you're in a business that's involved with a particular regulatory body. So for example, the Alberta Dental Association in College has suspended all non-emergency dental treatment and services. So if you're running a dental office, you need to be aware of that. If you're running a chiropractic office, you need to be aware of the college with respect to that. So we'll provide sources of information throughout this webinar as well. We're going to be talking about 5 kind of key topics today, and Matt and I are going to kind of switch back and forth. The first topic is, and you should see on the slide in front of you, but I'll go through it: information management and communications. Then we'll talk about working with your existing policies and agreements. We'll talk about planning for ongoing operations, business continuity, and the like. The fourth topic will go into accommodating employees, where we'll talk about things, leaves, temporary layoffs, other available options. And then we'll go into the further general obligations and rights of employers, where we'll discuss some of the occupational health and safety and WCB aspects that have arisen as a result of this. So given all of that as an introduction, I'm now going to move it to Matt to kind of discuss our first topic here on information management and communications.
Thanks very much, Anthony. So with respect to information management and communications during the pandemic, it's very important that employers stay informed, because as Anthony said, the information has been changing very quickly. There's inconsistent information that we have heard, and it is very likely that as greater restrictions are brought in, both by the government of Alberta and by the chief medical officer, it will have an impact on all of the things that we're about to talk about in terms of what the options are for employers. The other thing to keep in mind is the amount of information and frankly misinformation can be quite overwhelming. You may have employees coming to you asking about certain pieces of information that they have received. You may have gone online to look at some of the options that might exist from an employment perspective during periods of time like this. But it's very important that you ensure that the sources of your information are very accurate. So in terms of managing incoming information so that you can process and use that, we recommend highly that you look first to government resources. We're going to provide you with an email which sets out the links both to the Government of Alberta COVID-19 response site that is updated on a regular basis. It has a specific section that deals with information for employers and employees. As Anthony said before, it was actually inaccurate for a period of time, but it has been corrected. And our expectation is that it is likely that the Government of Alberta is going to use that as a way to get updated information out on a number of topics. But there, as I said, there is a section dealing specifically with information for employers and employees. There's also the Government of Canada website with respect to the coronavirus. And that is information that will be useful with respect to travel and similar sorts of restrictions. The World Health Organization, of course, is another source of information if you need international information. On legal issues, though, it's very important that you are aware of the limitations of information that is circling both in media and online. So we've seen a number of publications in mainstream media which talk about sort of options with respect to employment matters or labor matters. And it's vital that you understand that each of the provinces and in fact the federal government all have separate powers to regulate employment relationships, and they do so in different ways. So reports that you may see about how employers may be dealing with certain matters, or the tools that employers have to in fact deal with those matters, they're province specific. And so when you're reading a publication in the media, you need to be asking yourself, does this actually relate to the jurisdiction in which I am carrying on business? Because if it does not, then that information is going to be dangerous to rely on. And one of the other issues that you have, as I said before, will be employees coming to you and saying, look, I read this online, this is what I understand you can do. And you have to be aware of the fact that those media sources may not be dealing with your jurisdiction at all. The other important thing to keep in mind is that if you find a resource online that does say that it's dealing with the law of Alberta, or for example, options that are available to an employer with respect to temporary layoffs, for example, it may be out of date. And as you're all probably painfully aware at this stage, the last 4 years have seen massive changes in Alberta's employment laws. So our former NDP government brought in a number of important changes to Employment Standards Code and to the labor laws and related issues. Some of those have now actually been changed back by the Conservative government. And so when you're looking at information online, it's very important to look at the date that that information was posted. For example, information that you find online from before 2017 that is dealing with temporary layoffs is not going to be accurate. And it's very important to keep in mind that if you're thinking about using temporary layoffs for your business operations, and Anthony is going to talk about that in some greater detail, because that is one of the main topics that we've been asked to speak to clients on in the past week. It is very important that you follow the current state of the law with respect to how those temporary layoffs need to be done, because a failure to do that, if you're relying on information that was posted online from some time ago, could result in those temporary layoffs being invalid. And of course, when decisions are made quickly, it can result in real problems and financial consequences down the road. So that's with respect to the information that you are getting. Make sure that it's from sources dealing with your jurisdiction, and also make sure that it is up-to-date information so that you're not relying on old law. With respect to communications going out from employers, first we'll talk about communicating with employees. Not surprisingly, employees are overwhelmed with information. As I said before, some of it is inaccurate. Employees, not surprisingly, will be anxious about their health. They'll be anxious about their job security and the job security of other individuals in their home. And so sharing accurate and responsible or information responsibly has to be done in a way that has regard for the employer's legal obligations. So from an occupational health and safety perspective, as you all, I'm sure, are well aware, employers in all Canadian jurisdictions have an obligation to take reasonable steps to ensure the health and safety of workers. And it's important that when the employers are communicating information to their employees, they're doing so with that obligation in mind. That includes some of the measures that have been undertaken by provincial and federal governments to deal with some of the financial challenges that COVID-19 is going to cause, not only for businesses, but also for employees. This is a particular area that is developing very rapidly right now. In fact, just yesterday, the federal government announced some relief for employees. So there's temporary income supports for Canadians who don't have a paid sick leave or accommodation program and who are unable to work because of COVID-19. There are changed EI sickness benefits. As you probably have heard, the waiting period for employment insurance has been waived, and there's no longer a requirement for medical certificates. There's also emergency care benefits for employees who do not otherwise qualify for EI. And so those could include individuals who might be fall into the category of an independent contractor, but who nevertheless are affected by COVID-19, including all of the other implications that come from childcare and responsibilities for family members. There is long-term income support for workers who lose their job or have reduced hours as a result of COVID-19. And there's increases to the Canada Child Benefit and a one-time special payment through a GST credit for low-income families. So that's the federal government announcement. I think that there are good resources online to help individuals access those benefits. The provincial government is in the process of announcing benefits as well. What we're hoping, of course, is that there will be some concrete announcement with respect to some aid that will be available for employers, not only for employees, because of course employers are going to have a tough time getting through some of these issues as well. So with respect to those programs, often when you're communicating with employees, you can pass along that information as it's posted. Again, make sure you're passing on information from those government websites and making sure that you're dealing with accurate information. It's always a good idea in situations like this to designate one individual in your organization to manage those communications with your employees and also externally. Employees should generally be told that questions or concerns in relation to COVID-19 should first start by directing those questions or concerns to that communication point person. That person will then have the ability to determine who needs to be consulted in coming up with an answer or response to those questions or concerns. And you want to make sure that you have a unified voice when you're dealing with these issues, so that you don't have some individuals in your organization being told one thing and other individuals being told something else. So communications is very important with respect to ensuring that your employees are advised about what's going on. It's also a good idea to recommend that your employees not share COVID-19 related information on work platforms, including email. You probably will have seen a lot of misinformation that's been circulating on social media in terms of how to self-diagnose if you have COVID-19 or not. Turns out not a good idea to try to do that. And if you're seeing some of that misinformation being circulated in your workplace, it is a good idea to indicate that that communication should stop. And again, that the information that you will be providing to employees as required is coming from reputable sources. So no holding your breath for 10 seconds every morning and deciding that you don't have COVID-19. You want to reassure your employees that their health and safety is going to be a priority and to thank them for their cooperation in terms of mitigating the effects of this. It's important to have those sort of communications going out to your employees on a regular basis, because it is very likely that this is going to get worse in terms of the impacts for employees in the province. We're starting to see layoffs, some terminations occurring. There are, and Anthony will talk a bit about this with respect to potentially reducing work hours. I've had conversations with clients with respect to potentially looking at wage rollbacks in a way that was done in part in 2014 with the last downturn. All of those things will have negative impacts for employees, and it's important that you create an environment where employees understand that everyone is going to have to sort of pitch in and share the pain in order to get through these times. With respect to occupational health and safety obligations, if you have employees who are attending in the workplace, it's a very good idea to ensure that there are signs that you are putting up to indicate what your current restrictions are in the workplace. So even though everyone should know right now that hand washing and social distancing are mandatory things to do to try to reduce the spread of the pandemic, as an employer, you want to show that you are taking the steps to be telling your employees about that as well, and making sure that you're providing that information to them. So for example, if you have individuals who are coming to work, you should look at your office space. You should try to reconfigure that to ensure that there's a necessary distance between individuals who are working together. If you have empty offices that are available, it's a good idea to space people out as much as possible. That is part of satisfying your eventual obligation under occupational health and safety. With respect to communicating with clients and stakeholders and other vendors, it's important to let your clients and suppliers and any business contacts who might be coming into your office or your work environment to know what your organization is doing with respect to the response to COVID-19, and to communicate to them the workplace restrictions that you have in place, telling them, of course, that if any of them have any symptoms or have traveled internationally within the past 14 days, or perhaps even domestically within the past 14 days, that they should not be coming to your workplace, and ensure that employees know what those external messages are, what's expected if they're receiving inquiries from suppliers or clients, and that any other inquiries should be directed to the communications point person. So now Anthony is going to talk about how you use your existing policies and agreements during the pandemic.
Thanks. Thanks for that, Matt. So the starting point with respect to any issue dealing with your employees is your policies or in place, the contracts in place, or the collective agreement in place. So while COVID-19 and the issues arising for it are new, some of the response mechanisms are not. Any one of you who has called Matt or I on an issue, very likely the first thing that we'll say is, do you have a policy on relating to that? And in many ways, that is because from a legal perspective, that is your starting position. So if you're dealing with a medical leave, a sick leave, a family leave, what you have to look first at, what does the policy document say? Does it allow for paid leave? Does it require paid leave? Does a collective agreement require paid leave? What are the terms of it? Of course, in light of some of the directions from the chief medical officer, you will have to look at the possibility of waiving or amending certain requirements. So many sick leave policies, for example, require a medical note after so many days absent. That is should be waived, and it should be waived because in the circumstances, the chief medical officer has essentially said that employers should not be requiring this. And that doesn't mean that if you have that you should waive it forever. That doesn't mean that if you have, I would say, a reasonable, clear concern that someone is perhaps, hopefully not, but is perhaps abusing any sort of leave policy, that you still have any rights that you may have under the policy to request supporting evidence. But of course, you are going to want to, in these circumstances, I would say it's almost above a reasonable concern to a clear and compelling concern that you think that someone is behaving improperly or fraudulently with respect to the leave policy, because the doctors aren't going to want to see them, and you're not going to want the bad press that's going to come if you have to force someone to get a doctor's note in light of the recent climate. With respect to leaves, I'm going to talk in more detail in a later section regarding the employment standards leave that we mentioned earlier. Further, with respect to your employment policies and your collective agreements, you also have to look at any requests for remote work. Do you have a policy or something in place? If you don't, you may want to consider putting one in place, or from a default provision, you can look into, okay, can this person's work be done from home? Is that possible? And if so, of course, if someone's working for you, they have to get paid. If you are requiring them to be home when they don't have to be home, so they aren't actually quarantined, for example, then you may have to pay in those circumstances as well. So, however, if it's a circumstance where they are required to be home as a result of self-isolation or self-quarantine, then from a legal standpoint, there is no obligation to pay, except if your policy requires some sort of payment for sick leave or the like. So you'll want to keep those issues in mind when dealing with employees who, for example, are not attending the work because of a broader concern, as opposed to a directed self-isolation or something along those lines. And so, because in those cases, and we have seen a lot of them, where employees have said, well, I don't want to come in because we're supposed to be limiting contacts. Well, then you have to look into what is the actual reason why the employee's not coming in. Are they not coming in, and are they wanting to limit contacts because, for example, they have a compromised immune system? Because if so, then there may be some requirement to accommodate in that aspect. Or are they saying they don't want to come in for reasons of just general concern? If so, then there is an ability to require employees to attend work. Matt will talk more about the OH&S aspects with respect to that. But, it's important to understand that your operation still needs to operate, and you will still need people to operate it. And you can mitigate the concerns, but if those people need to come to work, then you're certainly allowed to require them to come to work. And if they don't come to work, then you may have to be in a position where you have to say, well, we have to bring someone else in to do your job. That sounds a bit harsh. And as Matt mentioned in his about communications with the employee, it is the best practice in these circumstances to not let it get to that point, to have an open dialogue with your employees about what the policies of the organization are, what the steps are going to be, and the importance of doing so. But if you're looking at getting voluntary participation from the employees, our recommendation is make sure that management has sat down and put a general plan in place first, because you need that plan. You don't want to talk to employees without that plan, and then the plan changes, and all of a sudden they're panicking because you said, oh, well, you might lose your job, but then it turns out you're going to just ask them to take a wage rollback or something like that instead. So it's important to do the planning first. I'll get into, when I next talk, the more of the specifics with respect to some of the leaves, if your policy or your collective agreement or your contract doesn't deal with certain aspects. But before that, as I said, the starting point should be making sure that you have a plan and understand what your plan is. And so for that, I'm going to turn it back to Matt to discuss ongoing operation planning in these circumstances.
Thanks, Anthony. So this deals more with sort of dealing with your business operations. That has a necessary impact on how you deal with employees, but you have to have a good sense first about how COVID-19 is likely to impact your organization. And the starting point should be considering who are the decision makers in your organization? Who are the individuals who are going to be empowered to make decisions about issues with respect to, for example, self-isolation or shutting down your workplace completely? In a private business, that could be and is likely the CEO or president, but that individual should discuss to what extent any board involvement might be beneficial. The decisions that have to be made, could be obviously very important to the ongoing existence of the organization. And so you want to make sure that you've identified the right people to make those calls. In public bodies, you can consider any need or benefit for decision-making or guidance from elected officials or for board level officials. You then have to ask what and who is essential to your business. So what are the aspects of the business that must continue to operate, and who do you need to ensure that that is there to make sure that happens? The other thing that organizations are doing and have been talking to us about is looking at differentiating between your mandatory expenditures and any discretionary spending that might be suspended or held in abeyance for a period of time until we really have a sense of the likely impact and length of the pandemic. And then from a planning perspective, in terms of projects that were underway, what projects can wait, what can be shelved, and what things are sort of essential for business moving forward. Business continuity plans are a really good way to address those and have all of the stakeholders address their minds to those issues. So a business continuity plan should be developed. It should always be developed with sort of a worst case scenario in mind, although we always hope for the best. We have to plan for the worst. So each operational area should be identified. Essential services should be identified. Who is going to resource those essential services should also be included in the plan, along with backups. And of course, as every organization these days has to have a plan for technological support, both internally, if you have internal technological support employees, but also externally. That is, what's your backup plan if the individuals that you rely on for your technology are no longer available because they may be sick and away from work. So there are a number of options. Once you've identified all of those needs and as you move forward, there are options in terms of how to deal with the economic impact of this. The one that, as I said before, we're hearing a lot of questions about are layoffs, because of course staffing costs are a significant part of the total cost of any organization. And Anthony's going to talk about the options that are available in more specifics for layoffs. There may be some examination of looking for employees to agree to work reduced hours. Sometimes that can be as a part of staggered work. So if you're looking to reduce the number of bodies that are actually in your workplace to make social distancing easier, but that you have to have some staff in the office to perform your regular work functions, you might look at changing hours of work for employees, extending the hours on one side, or changing the number of hours that your business is open each day in order to satisfy your legal obligations that you may have to stakeholders or clients or customers, but also to reduce the financial impact of essentially staying open for a full day when you might not have the business that really justifies it. And as I said before, there's also the possibility of looking at wage reductions. So for example, if you need to reduce someone's hours by 20%, that normally would go along with a wage reduction. There are always inherent risks in making those changes in an employment relationship. So again, as Anthony said, you need to be looking at your existing policies. You need to be looking at the employment agreements you have for affected employees to really determine how much flexibility you likely have with respect to making those changes. Our general perspective, well, my general perspective, I shouldn't speak on behalf of Anthony, is that in this sort of uncharted water that we're in, employers are likely going to have a little bit more leeway to try to make some of those changes, even if in other circumstances it might give rise to the ability for an employee to complain about it, potentially seek damages in relation to lost wages. If employers really are trying to find the best way to manage and balance their occupational health and safety requirements with the survival of their business, and doing that in a way that might have short-term implications for the terms and conditions of employment for their employees, my view is that you're going to have a greater degree of flexibility than you would have in other times, even greater flexibility than you may have had, for example, in economic downturns that have happened over the past 20 years. We're really dealing with an unprecedented situation with long-term financial impacts for organizations. So if you're in a situation where you may need to look at reducing staff or making changes to wages and hours, it's always a good idea to get specific legal advice before you take any of those steps. In part, that's to give you a sense of what both the legal risk might be in terms of giving someone an ability to complain either to regulators like employment standards or to file a complaint with the courts. But also just with respect to the practical risk of, is it likely to happen in this particular environment where many individuals, I think frankly, are going to be thankful that they retain their jobs and may understand that a reduction in hours or some other changes in terms and conditions are a necessary part of an organization being able to retain those employees over time. But it's just important to know that those kind of changes are traditionally the ones that do raise the risks of constructive dismissal complaints, for example, or employment standards complaints. And so the more you can sort of think through your business continuity plan, identify the changes you want to make, that will give you the tools to say, okay, from a workforce perspective, here's what we need to do. And then you look at the risks arising from making those changes. It's important to keep in mind that employees are expected to continue to work if they're able to, and that's always subject to reasonable accommodations that might be required in particular circumstances. But if you have the work and you are able to provide it to an employee, the general expectation is that employees will be in turn providing the work in accordance with their usual terms and conditions, or perhaps pursuant to some altered terms and conditions that may be required for one of the reasons we talked about earlier. That can, the accommodations that you may be looking at could be remote work. You have to deal with your IT provider to get that set up. You have to also not forget any of your security obligations or privacy protections if you have more individuals who are working remotely. So sometimes that can be, if you're allowing individuals to now use their personal home computers or their personal internet connections, there are additional security risks that arise from that. And just because we're in the middle of a pandemic and individuals need to work from home doesn't mean those other risks with respect to privacy and data security simply evaporate. So keep in mind that when you are looking at making those accommodations, you have to be thinking about still doing it in a way that you're maintaining the integrity of your business. So I'll turn it back over to Anthony now. He's going to talk about accommodating employees, and this is where we'll get into a bit more of the detail about some of the legal options that are available to employers.
So thanks, Matt. One of the first things I want to clarify is this Employment Standards Code leave that I had alluded to earlier. And following in the email you'll get following this webinar, we are going to provide you with copies of some of the orders in council that have recently been passed relating to employers, one of which is this order in council with respect to this 14 days leave. And why I refer to it as this 14 days leave is there was a lot of hullabaloo on Friday, just before the weekend, where there was an announcement made that the provincial government would be making this paid leave. And it was even described on the website afterwards as a paid leave. It caused a lot of confusion and concern. If you had talked to Matt or I in that interim time, we would have told you, well, we're not sure who's doing the paying or what that means, because there's no other paid leaves under the Employment Standards Code, so it would have been entirely novel. And sure enough, by the time the order in council itself was actually filed, and this was clarified by the government in question period, is they're expecting that the federal government will do the paying through employment insurance. So it's not going to be the employers. The actual leave, which they're actually calling the Employment Standards COVID-19 Leave Regulation, is a new leave. It is separate and apart from the long-term illness and disability leave of up to 16 weeks. That's already in the Employment Standards Code that was introduced in 2017, 2018. And what this leave is it's quite specific. It says that an employee is entitled to 14 consecutive days, so not business days, 14 days of unpaid leave if the employee is under quarantine. Quarantine is defined in the legislation as including, and that including is important for something I'll mention in a second, but including any self-isolation and self-quarantine as a result of COVID-19, as may be recommended or directed by the chief medical officer. So my interpretation of that is that, first of all, if there's a strict direction from the CMO that says that a specific person is quarantined, then obviously they qualify for the leave. But it also talks about where it's recommended by the chief medical officer. And in terms of the recommendations from the chief medical officer, the latest update that I would say is akin to a recommendation is anyone who's has cold or flu-like symptoms, or anyone who has recently returned from travel outside of Canada, or has been exposed to COVID-19 in the last 14 days. I would say that those would fall within items that are recommended by the chief medical officer to fall within that definition of quarantine. So that isn't just because the chief medical officer says, people should be trying to keep 2 meters apart and things like that. That's not going to be sufficient to initiate this leave. A couple of other things with respect to this leave is it doesn't require a medical note or a medical certificate, unlike the long-term illness leave. And there's no requirement of being employed for 90 days before it starts, as with all the other leaves. So your employee from day one is entitled to this leave. And it doesn't impact their 16 weeks long-term illness leave. So if it's someone who does get COVID-19 and suffers complications as a result, they could potentially rely on the longer 16 weeks on top of the 14 days that they're already required to. So it's not a 14 days paid leave. It's a leave that I would say applies in very particular circumstances. Employees are still permitted their 5 days of personal and responsibility leave under the Employment Standards Code. And so, because one of the questions I get is, well, what if we have employees who are concerned about coming in? Maybe because one of our coworkers is ill or has a family member who has been diagnosed with COVID-19. What do we do in those circumstances? I think that there's a legitimate argument for an employee for the personal responsibility leave, which is a 5 days leave. Because that's defined as any leave that's necessary for the health of an employee, and I would consider that mental health, psychological health would fall within that. So, if an employee has those unpaid leaves, the personal responsibility leave, you can't terminate them for taking that leave, just like you can't terminate an employee for taking this 14 days leave. Now, if the employee doesn't have those leaves, but they still don't want to come in, you may want to, as an employer, you may want to consider if there are ways you can support them in doing so. And this can be done on an employer by employer basis. Again, going back to the policies, do they have a sick leave benefits pay that they could use? Do they have, do they have a PTO, a paid time off system in place? In some circumstances, you may be able to get them to agree to be paid out their vacation pay and take some time off. So there's flexibility in those cases, but if they are essential, as Matt has mentioned, after you've done your planning and you figured out who you need, then you may be able to require them to attend, subject to any human rights or OH&S issues. So that's the employment standards leaves aspect in terms of dealing with accommodating your employees. The second big aspect is temporary layoffs. And a quick terminology point, often when people are talking about being laid off, they actually are meaning having their employment terminated. I was laid off. Well, no, you were let go. You were terminated. A temporary layoff is a specific concept that comes out of the Employment Standards Code legislation, where essentially the people stay as an employee. The individual stays an employee of the organization, but they're not paid. They're not expected to come into work, and with the intent that they would be recalled at a later date. This is quite common, for example, in a lot of trade industries, where, okay, you know, our welding work is really slow right now. We don't have that big contract anymore. We just completed it. We're hoping to get this new contract and things will pick up again in a month or two. And that's the typical scenario where we see it. That being said, we're finding that for a lot of employers, you know, particularly anyone in the hospitality industry, anyone in the in health services that's not related to treating individuals, so dental offices, chiropractic offices, pharmacies, that this is a mechanism that they may be able to avail themselves of. There are, now I should say, if it's a unionized workplace, there are almost always a layoff clause in the collective agreement, so start with the layoff clause there. If you're going to do a temporary layoff, there are strict criteria under the Employment Standards Code as to what kind of notice you have to provide, what it has to be in writing. It has to include sections from the Employment Standards Code. This has changed, so as Matt said, if you're looking at a source from before 2017, you actually didn't have to provide the same types of notice and the same requirements. So it has changed significantly. It's not something that most employers have experience with, and so it is important to get legal advice on when using a temporary layoff. One of the reasons being because traditionally a temporary layoff would be considered potentially what's called at law constructive dismissal, because where the law says, well, you essentially fired that person. Because what a temporary layoff allows an employer to do, in the most extreme scenario where it's used a full 60 days, for example, is you have an employee for 12 months, but you've only paid them for 10. Well, a lot of people would say, if you cut over 10% of my pay, well, then that's not the job I signed up for. And so I'd be constructively dismissed. There is still a risk, if there's nothing in your policies or contracts, that a temporary layoff could be, that would allow a temporary layoff, that a temporary layoff could be considered constructive dismissal. But as Matt had mentioned, and I'm of the same opinion, given the unique circumstances the world, but particularly Alberta employers are dealing with not only COVID-19, but the price of oil issues that happened at the exact same time and are just getting worse, that this beats the option of the company having to close down and potentially declare creditor protection, in which case those employees would not get anything. There is an obligation to recall employees within 60 days, subject to some exceptions. And those that are within the legislation, one of which is that we found a lot of employers are doing are continuing benefits for their employees. So they're laid off, they're not getting a salary, but they're still getting benefits. When they're laid off, they will qualify for EI. And so this may be one consideration for employers to take into account. And I should say, I can't guarantee they'll qualify for EI, because EI has requirements for number of hours worked and the like, and there's also new plans being put in place. But unlike a reduced pay, a layoff will most likely qualify an employee to get for EI. One thing to be aware of is that the waiting period that was waived with respect to EI to date has only been waived for sick leave, so it will not apply to people getting EI benefits as a result of a layoff. So they'll still have that 1 week waiting period, although I would not be surprised to see that changed. In connection with temporary layoff, an employer can enter into something called a supplemental unemployment benefit plan. This is something that it needs to be an application that's submitted to Service Canada, but it is a way to assist employees who you've laid off where you can still provide them with some amount, some top up, that will not impact their EI earnings, because otherwise any income can reduce can potentially reduce their EI amount. So for those employers that are looking at laying people off, but still think that there's the economic resources to at least provide some pay to your employees during this period, that's certainly something that's worth looking into or considering. Another option, if you're not dealing with a temporary layoff, is considering whether to do a reduction of hours or salary, and so a wage rollback. Again, this could amount to, in some circumstances, constructive dismissal, but there have been cases where a wage rollback of even up to 20% in specific economic circumstances has not been considered a constructive dismissal. But when doing one has to be careful. And, for example, you look at the policy, you look at the contract, you look at the collective agreement, and it's based on the case law, in my opinion, it's much more defensible if it's done on a reasonably objective basis. So for example, everyone's pay is getting cut, or everyone in this department's pay is getting cut by a certain amount. If it ends up being specific people, there are potential issues that arise from people feeling targeted, from potential human rights set up. There are also EI options with respect to this. There's the work sharing program, where if someone's compensation or schedule is reduced by between 10 and 50%, they may be able to get EI benefits through the work sharing program. There's an application process for it, and the employer will have to show that there's been a shortage of work and a decrease in business activity. And there's some other requirements for eligibility. There's still the federal government recently announced some changes to this program in response to this COVID-19 crisis. But there's still a requirement that your application has to come in 30 days before the wage supplement would apply. So this is a solution that can be implemented today. It would take effect 30 days from when the application is submitted. Matt had recently mentioned the emergency care and emergency support benefits. Just to give a couple details that were recently announced by the federal government. Those will be administered by the CRA. Understanding is that workers, it's something that'll be granted to workers. Applications are going to be opened up in April 2020, so they're not available yet. But it's essentially income support for a lot of the groups that might not necessarily get coverage through other avenues with respect to EI or with respect to, so people who have to take care of their loved ones, so they wouldn't qualify for EI sickness benefits, but they have to take time off work as a result. So that it would be important to advise your employees of that, particularly if you're doing a layoff and they may not qualify for EI benefits otherwise. Another thing that all employers should be aware of, or at least those who are eligible for the small business deduction, including nonprofits and charities, that was just announced as a wage subsidy program, where the federal government is going to offer a wage subsidy for small businesses who face revenue losses for a period of 90 days, up to $25,000 for employers. So that's a program that's just recently been announced. It's important to be aware of. I've touched on a couple times human rights. A couple of the key human rights considerations to keep in mind as you are considering your workplace and what you're going to do is, this is an ancillary effect of the COVID-19 issue, but if people have childcare obligations, that is a protected human rights ground on family status. So if someone needs to take time off to get their childcare situation sorted out, then the baseline accommodation you would likely have to provide is at least an unpaid leave for them to do that. So keep that in mind, that those will need to be dealt with on a case-by-case basis. There is a little dispute, say even within our office, as to whether COVID-19 itself, if someone's ill with that, whether that would engage a human rights issue. Frankly, I see that being a minor concern, but if something like that comes up, we can have discussions with respect to that. So just as a quick summary, so that's some of the specifics in terms of if there's any leaves that can be taken advantage of, looking at potential layoffs or wage rollbacks, reduced pay. Those are kind of the things that some employers can do to take advantage of in order to keep functioning in what is a very difficult time, and helping their employees as well as they get through this. And so I'm now going to move it over to Matt to kind of hit our last topic involving some of the OH&S and WCB setups with respect to this. And I note that we're close for time. I expect if we go over a bit, I hope you'll be able to stay with us. Otherwise, please feel free to reach out to either Matt or I. You'll get our information with the follow-up email.
Thank you for leaving me 3 minutes, Anthony, for the last topic. I want to mention 3 things before I move to that topic. When Anthony talked about the temporary layoff provisions, it's very important to underline that they have very specific requirements, and that one of the changes from the pre-2017 to post-2017 provisions is that now have to give employees notice of the temporary layoff itself of either 1 or 2 weeks, depending on how long they've been with your organization. There's an exception to that where there's unforeseeable circumstances, then you have to give notice as soon as is practicable. It is unknown whether or not this would qualify for the language in the code with respect to unforeseeable circumstances. But I kind of think that if this doesn't, I don't know what would, to be frank. So just keep in mind that those notice requirements are important, and that there are different rules in place on that issue in each province. So don't assume that you can do a temporary layoff in Saskatchewan, for example. It's very different rules there. And keep in mind that when we're talking about a temporary layoff in Alberta, that allows you up to 60 days, or in some other circumstances it can be extended, but that gets more complicated. So generally speaking, it's up to 60 days. If you don't recall the employee at the end of that 60-day period, your obligations to then provide termination pay or severance pay still exist, and you would still have to then pay those things at the time. So you're not getting rid of those obligations, you're essentially delaying them if you don't call those people back. I just wanted to underline those points because I think it's important to have a good understanding of what that tool really is.
Sorry to interrupt. I had, because this has come up from a few people, there's no obligation to pay out a vacation accrual if you're doing a temporary layoff, only on termination. Sorry, I've had that question a few times, so I wanted to make sure that was clear.
Yeah, so an employee on temporary layoff would maintain their accrued but unused vacation. And then, as Anthony said, if they're terminated after that 60-day period, then of course you'd have to pay it out. So just with respect to obligations and rights, again, what we're talking about mainly are occupational health and safety issues, and we've touched on that already. You have to make sure that you are importing the requirements from Alberta Health Services into your workplace. So employees have to be required to notify you if they're sick or if a close contact is sick with any of the symptoms of COVID-19. Then you deal with the issues with respect to self-isolation and quarantine as a result of travel, changing, as I said before, the physical setup of your office, ensuring that there's hand washing stations present. Anthony has developed his own Reynolds Mirth themed jingle for hand washing, which he can share with you after we're finished here today. And so if you go to the Occupational Health and Safety website, you'll find good resources about minimizing risks for respiratory viruses in the workplace. Great resource to look at, and of course, communicate that to all of your staff as well. We've talked about international travel. If you have people that are traveling for work, if it's not essential, of course, that travel should be postponed. And in fact, because of borders being closed, you may not have much choice in that matter in any event. But avoid a situation where an employee is going to say, look, there are risks and you sort of put me in harm's way by requiring me to do something that government is telling us that we should not do. When you're communicating internally, if you have an individual who has contracted COVID-19, remember that privacy rights don't disappear in these kind of circumstances. And so any information that is classified as medical should generally not be shared or be shared internally on need-to-know basis. So, generally people are going to know if someone has contracted that. People who are working in that area in the workplace might have to leave so that there can be sort of a deep cleaning being done. But just be cognizant of the fact that you don't want to be talking about an individual's medical situation with other workers in the workplace. With respect to workers' compensation, COVID-19 is only a WCB issue where the workers contracted it as a direct result of their employment. So this is going to be relevant mainly in healthcare settings, frontline workers, and other individuals who work in that area. And WCB has published something on their website. There's really two considerations they're going to look at is, one, did the nature of the employment involve sufficient exposure to the source of the infection and cause that condition? Or does the nature of employment create a greater risk of exposure for the worker than for the general public? So if an employer is forcing employees to continue physically working at a location where they come into contact with a significant number of individuals, then there may be some risk with respect to a WCB matter. But since the question is really the nature of employment, for employers where the risk is greater, you don't need to report where an employee, where the risk is not greater. So if you have an office environment that is not connected to healthcare, for example, you're not going to have to report to WCB that an individual caught COVID-19 from a coworker or a client. Now, there are obligations to report WCB. If you're ever in any doubt as to which category you fall into, then you want to seek legal advice or speak with someone at WCB to see if you do have an obligation to make that report. That looks like we're just about 3 minutes over time. Thank you for everyone who has stayed with us. We hope that some of this information is useful. As Anthony mentioned at the outset, this is a rapidly changing situation. It is very difficult for everyone to stay current with all the information that is coming out. We are doing our best to make sure that we have the most current information to provide to you. But again, make sure that you're getting your information from trusted sources. And as you move forward, to ensure that you're able to really manage those employment risks and obligations in a productive and efficient way. So thank you very much for virtually attending. We assume that many of you are like us in our homes, although you don't have the disadvantage of having to have a bedroom in the background, for example. But we appreciate your attention. If you have any follow-up questions, please feel free to reach out to us. Everyone, take care.
Thank you.